As a follow-up to the opinion summary, I wanted to provide some contrast between the opinion and the oral argument in the May 22nd, 2025 Supreme Court opinion in Kousisis versus United States, case number 23-909. The oral argument transcript from December 9, 2024 provides considerable insight into how the justices' questions and concerns directly shaped their opinions. The transcript reveals early indicators of the fractured approach that would emerge in the final decision, with each justice's line of questioning foreshadowing their ultimate positions on the reach of the federal fraud statute at issue here. Starting with Justice Barrett. At oral argument, Justice Barrett focused primarily on the uniqueness exception that the petitioner proposed, asking questions about how to distinguish between items requiring specific performance, like a grandfather's portrait or Grover Cleveland, and ordinary commercial goods. Her questions early on in the oral argument suggested skepticism about creating arbitrary distinctions. She said, for example, quote, "How do you know if it's so subjective?" End quote. And later challenging the coherence of the uniqueness standard. Justice Barrett's majority opinion directly reflects this skepticism. She wrote, quote, "At the right level of specificity, anything can be described as unique or different from something else." End quote. This mirrors her oral argument questioning about the lack of a, quote, "principled way to draw the line," end quote, between unique and non-unique items. Her ultimate rejection of petitioner's economic loss requirement flows directly from her recognition during the oral argument that their proposed exceptions lacked coherent boundaries. Justice Barrett's written opinion extensively analyzed common law fraud doctrines and went so far as to distinguish between rescission, false pretenses, and deceit. This comprehensive approach was addressed in her engagement at oral argument, though the transcript shows she was initially more focused on the practical application than the historical analysis that dominated her written opinion. As far as Justice Thomas, his questions specifically explored the frequency of DBE fraud prosecution and what distinguished this case from others. During oral argument, he asked, quote, "So what distinguishes this case from others? It would seem that with many contracts, the broad use or wide use of these contracts, that you would have a history of some fraud litigation," end quote. This line of inquiry clearly foreshadowed his written concurrence and the detailed analysis of DBE program issues. Justice Thomas's concurring opinion's central thesis, skepticism about the materiality of DBE requirements, was telegraphed during his colloquy about whether certain conduct should constitute fraud. His hypothetical about a company promising to give patios to veterans revealed his thinking about when regulatory compliance requirements truly matter to the essence of a bargain. While not extensively explored during oral argument, Justice Thomas's written opinion's discussion of the DBE program's constitutional vulnerabilities reflected his broader jurisprudential concerns about race-based classifications. Justice Gorsuch's concurrence. During oral arguments, Justice Gorsuch extensively questioned the petitioner and the respondent in areas that previewed his written concurrence. For example, Justice Gorsuch pressed petitioner Fisher on the traditional common law fraud requirement. Quote, "I take your point that there's got to be an injury requirement. There's certainly was at common law fraud, but the government says that's not necessary. Materiality will do all the work. What's the problem with that?" End quote. In addition, Justice Gorsuch's written opinion's discussion of the benefit of the bargain rule was directly foreshadowed by his oral argument's focus on specific performance. His questioning about whether this case was, quote, like the horse or the painting or any other specific performance case, end quote, became central to his written analysis that distinguished between cases where victims receive what they bargained for versus cases involving specific unique items. Justice Gorsuch's questioning of government counsel about whether there was actual economic injury in this case revealed his thinking. When the government lawyer acknowledged that the government had preserved an economic loss argument, Gorsuch immediately seized on this concession and said, quote, so if that's the case, why are we here? I mean, if there is an injury and it's economic, can't we resolve the case on that ground? End quote. This exchange explains why Justice Gorsuch's written concurrence characterized the majority's broader pronouncements as unnecessary dicta. The babysitter hypothetical that features prominently in Justice Gorsuch's written opinion was extensively developed during oral argument. His written criticism of turning victimless lies into federal felonies stems directly from his persistence returned to this example throughout the argument and demonstrated how his belief about how ordinary misrepresentations could become criminalized under the government's theory. Justice Sotomayor's concurrence advocates for resolving only the narrow economic loss question presented. This approach was clearly signaled during oral argument when she pressed the government's counsel. Quote, I thought the only thing you wanted us to do was to say that we reject petitioners' net pecuniary loss requirement, correct? But you want me to go, do you want us to go further? End quote. Her insistence on limiting the court's holding reflects her judicial philosophy of deciding cases narrowly. Justice Sotomayor's robust defense of the DBE requirement's materiality in her written opinion builds directly on her oral argument questioning. At oral argument, she distinguished this case from broader fraudulent inducement scenarios. For example, she said, quote, this is not the case of the babysitter, end quote, and, quote, this is not fraudulent inducement in the sense of those examples, end quote. Her written opinion's detailed analysis of why the DBE requirements were material to the essence of the bargain reflects this same precision in distinguishing factual scenarios. Her written rejection of Justice Thomas's materiality concerns were also previewed during oral argument when she challenged various hypotheticals that might undermine the government's position and consistently returning to the specific facts of this case rather than engaging with broader theoretical concerns. In conclusion, oral arguments revealed that while all justices agreed on rejecting the economic loss requirement, their different concerns and questioning approaches during oral argument directly predicted the fragmented reasoning that would characterize their written opinions. I hope you enjoyed this analysis. I have in the show notes a link to both the oral arguments and to the opinion summaries. Hope you enjoy. Thank you.